slightly before we were, but they were recognized after the Lumbees were recognized in 1885 by the state, by Congress in a special act in 1891. There was a special act of Congress that directed the Secretary of the Interior to prepare a roll for the Eastern Band of Cherokee and enroll them and to place their land in trust. So that's just the way it's done usually. Yes?
You mentioned that your opponents largely are funded by casinos. And gaming is, of course, one of the big bugaboos in Indian country.
Right.
Could you amplify a little bit on how gaming plays into the issue of
Recognition. That's a very good question. You know, the Indian Gaming Regulatory Act was passed by Congress in 1988. And it came quickly on the heels of the Cabazon decision, which said that Indian tribes could do gaming independent of state control. Ever since 1988, with the passage of IGRA, Congress has suspected that every tribe that sought federal recognition did so because they wanted to do a casino. I can identify at least 4 tribes for you whose petitions for recognition before the BIA were basically walked down because of opposition in the state to Indian gaming, not because of recognition. It is, like they call, say on Congress, a hot button issue. It creates a suspicion that the tribe is doing it for reasons other than true recognition. That's one advantage that the Lumbees have. I mean, we can say, look, we were at it for 100 years before IGRA was passed. And so, obviously, if this is not about gaming, this is about other things for the Lumbee people. But you're right, it has definitely poisoned the well because it has made members of Congress suspicious about every tribe that seeks recognition. And not only from Congress, but also through the BIA process.
Yeah, I know there's a lot of money, federal government money, that's coming into the Lumbee country. It's called their Indian, like in our headquarters, building this building, Indian education, Indian housing. There's a lot of, what can I make of that?
That's a good question. Because we are state recognized, we are eligible for certain federal services that go to Indian people. HUD Indian housing, Indian education, some higher education grants for the health fields, for example, are made available to not only federally recognized tribes, but also state recognized tribes. So we get those services because we are state recognized. There are only 2 agencies that would be impacted by recognition of Lumbee, and those are the 2 agencies that limit their services only to federally recognized tribes, and that's the Bureau of Indian Affairs and Indian Health Services. So in that sense, recognition of the Lumbee bill will have a smaller budget impact than recognition of a tribe that didn't even have state recognition. Because our recognition doesn't affect all those other agencies, Department of Education, Department of Interior, Energy, Housing, HUD, none of that would be affected because we are already state recognized. Yes, sir.
I guess the obvious question is, how do you foresee the recent contract that the tribe signed with the Limited Liability Corporation affecting the current bill that's in the Senate now, if that contract isn't repealed?
Well, let me start by saying I have certain restrictions on what I can say about that as a former representative of the tribe. You know, I've been replaced, as you obviously know, by the Lewin contract, but even as the former attorney for the tribe, I have an ethical obligation to do nothing that would hurt the tribe's interest. And so all I can say is I pray that our bill makes it. I remain hopeful. I am worried. I think association with gaming, and I've said this publicly, so I'm not talking out of school. I think that association with gaming is damaging to our bill. I think it undermines the tribe's credibility. Because we told Congress we were not interested in a casino, and that's in large measure why our bill was passed by the House